Hello and welcome to our first part of a three-part series on estate planning. We are so happy to have you with us today. We are having just a couple of housekeeping items just to make sure we are all on the same page. One is that this webinar is recorded, so don't worry. After the webinar, you will receive a recording of the webinar in your email, so you can go back, you can view it with your loved ones, etc. Additionally, like I mentioned at the beginning, this part one of a three-part series. So we will also have part two of estate planning tomorrow at 10 a.m. And then we will also have a webinar on Thursday, I'm getting my days confused, at 10 a.m. as well about what to do when a loved one passes away and how to report it to the IDB. Additionally, if you have questions, please make sure you put them in the Q&A box to the lower right. We will be answering as many as we can at the end of the webinar. Our presenter today is Mr. Nicholas Fobé. He's a wonderful and esteemed attorney. I have a couple of data points on him. He grew up in Belgium. He's learned French, Dutch, English, German, and I believe currently, if he hasn't already, mastered Spanish. So we are extremely excited to have him here today. Not only is he extremely talented in the law portion of this, but he is also, I just learned today, a viola player. So if you're in the Bethesda area, be sure to attend his concert this Sunday, April 14th. Additionally, this webinar is subtitled. So if you want to see the webinar with subtitles turned on, please go to the lower right-hand corner. You will see a green button. On that button, there will be a little chain symbol. Click there, and you can choose either English or Spanish to view this webinar. Si desea ver este webinar con subtítulos, haga clic en el botón verde con el símbolo de un enlace y seleccione inglés o español. Without further ado, I want to pass the webinar to our esteemed speaker, Mr. Fobé, and he will take you through all of the content. Have a wonderful day, everyone. Mr. Fobé, it's yours.
Gracias, un millón de gracias, Marilyn. Siempre un placer hablar con usted y hablar con IDB Global, pero ahora voy a cambiar en inglés y es más fácil para todos. So, thank you very much for your kind introduction. Yes, I am the founding partner of Verstegen and Fob, and we do specialize in estate planning for citizens and non-citizens. I am originally from Belgium, came to this country a long time ago, learned the ropes, learned the rules, and I sort of developed an interest on how laws affect citizens and non-citizens differently. So I had to really learn the ropes, and I want to impart some of this information with you. And again, a little known fact, again, now the cat is out of the bag, I suppose. One of my hobbies is to play viola in chamber orchestras. I do a lot of chamber music. Now, as it happens, we do give a concert on Sunday at 2 p.m. at Bradley Hills Presbyterian Church. A fabulous soloist, 16-year-old, will play Bach Concerto for violin, Haydn Concerto. We're going to do a Mendelssohn Simple Symphony and a Britten Symphony. So great concerts. It's free admission. Any donations that are made are actually going to support Bethesda Help. That's a food charity. Last year, we were able to raise $20,000 for the food pantry. So again, hope to see a lot of you there. If you have something you want to do this Sunday, 2 p.m., Bradley Hills Presbyterian. Anyhow, back to the topic at hand, estate planning. Very, very important topic. Again, it is not financial planning. This is estate planning. So we're really talking about protecting your estate. Okay, now your estate really consists of your assets. What do you have in terms of possessions, right? Your house, your car, your bank accounts, all of that is considered your estate. And as a side note, estate planning is probably even more important for non-citizens than for citizens. And the reason I'm saying that is that a lot of non-citizens come from South America, Europe, a lot of civil law countries where everything is regulated. Whether you have a will or you don't have a will, the end result is the same. Now, this is not the case here. In this country, you really, really have to plan. You have to have your documents in place. Otherwise, you have some consequences that are pretty drastic. So let's move on and talk a little bit about the various goals of of estate planning. Now, again, you will see as we go through this presentation that a lot of it has to do, with controlling things. Either you control things, you organize, you avoid surprises, you avoid headaches for loved ones, by controlling things with important documents. Making it much easier for yourself or for others. People who don't care. People who don't care about control, they say, if I pass away, it's really not my problem. Well, obviously, those kinds of people, for them, estate planning is just not important because they don't care. But I think I'm pretty sure that most of you in the audience care a great deal. Otherwise, you wouldn't even be attending this seminar. So what are the typical things that you can control and that people sort of worry about, right? I mean, imagine you're a young mother, you just had a baby. Well, the question comes up, my God, who will take care of my baby? If something happens to me, where is he going to go? I mean, I don't want him in foster care, right? So you worry about these things, and you should, and you can, control these things by having guardianship nominations, in your documents. So another worry for people, if I pass away, I don't have a will, I didn't do anything, is the state going to take all of my assets? I worry about taxes. I've heard that as a non-citizen that my taxes will be much higher. So I worry about, a lot of my estate diminishing because of high taxes. I also worry about how expensive is it going to be for survivors to take care of all this. Okay, people worry about that. People worry about who is going to be handling things for me if I'm incapacitated, if I pass away. Who's going to do that? Now, some of you will say, well, my entire family is overseas. I'm here by myself. So how can people from my home country be stepping in? Do they even qualify to step in and take care of things for me? And some of you, of course, with minor or young children also worry about, wait a minute, if something happens to me, my children still have to go to college. They have needs. They have to. So who's going to provide for them, and how are we going to provide for them? Can somebody else step in and, you have funds available for those young beneficiaries until they, for example, would be old enough to inherit themselves. So as you can see, estate planning, to me, it's a fascinating field because we really can take care of many, many different aspects. Some are more important to some people than others, but all of them, I believe, are very important. So bottom line, estate planning, you protect your assets, you protect yourself, and you protect survivors. All right. Next slide here, we are going to talk about various documents. So estate planning, an estate plan does require you to sign documents. You just don't, you can tell me everything you want. You can tell me these are all my decisions, until you've come to my office and actually signed those papers, there is zero protection, right? So you have to have papers. Advice is not good enough. And typically, all estate plans should contain a will and a trust, or a will or a trust, and we'll talk about that. Everybody should have a power of attorney, okay, a durable power of attorney, and everyone should also have medical directives. Sometimes they're called advanced medical directives. And some people come to me and say, well, we don't really need an estate plan. I have a power of attorney, and, somebody can step in and do whatever for me in case, I pass away. Wrong. Absolutely wrong. You should know that a power of attorney, the minute you pass away, has no more validity and ends. So nobody can step in after you pass away. Some people say, well, I have all my assets joined with somebody, so I don't really need anything. Again, that's wrong too. Joint assets it's not an estate plan, because both of you could pass away at the same time, or one of you passes away and then everything, is in the name of the survivor, so that's not good enough. Some people say, well, I'm just putting beneficiary designations on everything and therefore I don't need an estate plan. No, that's not enough. There's so many different aspects that, you really need those documents that are listed here. Okay, so typically in an estate plan, you will have a will. Now, of course, a will is an official document that becomes effective upon death, and it basically names guardians for minor children, names executors who can take care of the estate, and it also has decisions as to where the assets should go. Now, again, wills do go through probate, and I'll explain to you what that means in a minute, but it basically means that, your estate will go through the court process, okay? A trust is a very commonly used document where people create a trust, and I'll explain trust to you in a minute. But again, a trust is a way to have your wishes expressed and have no probate. Okay, so you can have either a will or a trust. And then the financial power of attorney is something that everybody should have, because if you don't have one and you become incapacitated, somebody has to go to court to become your guardian. And again, avoiding court really saves time and money. So power of attorney also can be used even if you're not incapacitated. Again, if you travel, you're on mission, and you're in the middle of purchasing a house, selling a house, it's very practical to be able to designate someone who could then sign for you. It's a very useful, very practical document. And the medical directives, again, you have a power of attorney. If you cannot make your own medical decisions, again, it is important for you to name someone who makes those decisions. The medical directive should also have a living will. Now, a living will has nothing to do with a will. It's simply a document that expresses whether you want to be put on life support if you're end stage, if there's no expectation of recovery, should they connect you to all kinds of medical devices, which obviously will cost and will kind of drain your estate after a while, because, the insurance will not keep paying for somebody on life support, for a very long time. And again, your medical records, you should also consent to the release of your medical records in case your family needs those documents. So the question that I'm always asked is, why do attorneys have to prepare these documents? Can't you just get it from Google or Zoom or whatever? Well, the question, the answer, I should say, really is that estate planning, again, is state-specific, number one. So each state has somewhat different documents, different requirements that are very important. And sometimes when, you're dealing with international clients who have assets in one country, assets here, things get more complicated, and you really benefit from talking to an expert, somebody that deals with this, versus having something. I've had so many people they try something, it doesn't work, and they still end up coming with me and said, well, we need a person that can actually tailor things to our situation. So, dealing with a professional, I believe, is the way to go. Anyhow, so these are the documents that I think everybody should have. One final note on this slide. Hopefully not too many of you don't have any documents, right? If you have not yet done any estate planning, what happens? Well, if you don't have anything, basically all decisions are made for you. Your entire estate is going to be frozen. Your state is going to decide what happens with your assets based on, statutory provisions. So really, it's not the best way to, go about your situation. All right, so no documents is certainly not a recommended situation. All right, I did mention wills that go through probate, trusts that do not go through probate. Therefore, we might as well talk a little bit about what that means. Okay, so let me give you an example. Suppose you're a single person. Okay, all of your assets are in your name. You pass away. What do you think happens? What do you think happens? Well, all of your assets that are in your name are frozen. Frozen. The owner passed away. No one has access to it. So what can you do? Okay, so family survivors, basically have to go to court. You go to court and you tell the court, well, such and such person passed away. And of course, the question becomes, did the person have a will, or the person did not have a will? But you still have to go to court and have somebody appointed as an executor who then gets court authority to transfer those assets according to the provisions of the will, if there is a will, or according to state law if there is no will. Okay, so that is basically a state process. Again, this takes place in the Circuit Court of Virginia, Circuit Court of Maryland, or the DC Superior Court. So it is the state where you reside. It's your, if you're a resident of DC, well, you pass away, your estate will be handled through the DC probate court. So it is a lengthy process. It is a lengthy process. You have to, the court has all kinds of requirements. You have to file a petition for probate. You have to do inventories of the assets. Bills have to be paid. Creditors have to be notified. Newspaper articles have to be published about who's named as an executor. At the end of the probate process, there's actually a freeze for creditors to come forward. At the end of the process, assets can be, distributed to beneficiaries. So one thing to understand is that probate can be avoided, and avoiding probate is, again, we'll talk about that in a minute, but not all assets, and this is very important, are considered probate assets. So you have some control over, how your assets are titled. So let me give you an example of what probate assets are and what non-probate assets are. So again, my example, single person, all of your assets are in your own individual name, and there are no beneficiary on those assets. Well, those are probate assets. The only way to get those transfers is to go to court. If you have a property with somebody else and it's titled tenants in common, well, your 50% or whatever interest you have is considered a probate asset. If you have on your life insurance, or you have on your pension, some beneficiary designations that say, upon my death, it goes to my estate, it goes to my executor or personal representative. Again, those assets become probate assets. So again, I recommend that you check all your beneficiary designations and never, never, never have executor, estate, or personal representative listed on there. You really want to list a person or a trust or something like that. So again, non-probate assets would be assets that are connected to a trust. Okay, if you have assets in a trust, they do not go through probate. If you have joint assets with right of survivorship, okay, then the survivor gets it automatically. So, but the danger here, a joint asset at the death of one person becomes an individual asset. So, you have to keep making a joint and joint and joint. And sometimes people, forget about that. It is possible at the credit union and for financial institutions to do what is called a TOD. Okay, TOD means it's your individual account, but if you pass away, it transfers upon death automatically to a person or a trust. So that's something that the credit union can help you with. Again, beneficiary designations on life insurance and pensions, again, make sure you put a person, a trust, or something like that. And that is a way for those particular assets to, to avoid probate. Okay, not going to court actually is a big relief for the survivors. I just finished probate for, one of my clients, and it absolutely took over a year to go through all of the formalities. And unfortunately, when you go to probate, the courts, I mean, they want to look at everything that comes in, everything that comes out. Who are you paying? What debts were there? So they audit everything. And, the case we just did, I mean, they kept auditing three times, for a small estate that really had nothing worth auditing. But again, those people just do their jobs, and but it truly is a headache for the survivors, right? So are there good reasons to avoid probate? Well, I think there are many, many reasons for trying to avoid probate. And again, it is expensive. Okay, you have to pay court costs. Every time you file something with the court, they charge you a certain amount. Publication costs, insurance costs. You have to pay a bond fee potentially. Executor commissions. Unfortunately, lawyers cannot work for free. So, lawyers typically charge on an hourly basis for probate work, and the time just adds up. Okay, probate is very time consuming. Nothing gets done in less than a year. And why does it take so long? Again, nothing's going to happen. Assets cannot be distributed to survivors until 6 months have passed, because the court wants to first pay creditors. All of the debts have to be paid first. And, a lot of my clients don't really have debts. I mean, you pay off a couple of credit cards, you pay funeral expenses, but there really are no debts, but you still have to wait 6 months, okay, for a potential gambling debt or who knows. Anyhow, probate is inflexible. You have to have local executors. So a lot of my international clients, like, well, I can't even name my spouse as an executor for my will because he or she is a G4. She's not a permanent resident. Okay, or so so a lot of rules that have to be followed, deadlines, and so forth. Now, probate again takes place. Takes place in your state of residence, so that would be the main probate that covers accounts, properties, and so forth. However, some of my clients live in one state but have a property in a different state. Again, my classic example over here would be the Delaware beach house, right? So you live in Virginia, Maryland, or DC, but you're lucky enough to have a beach house in Rehoboth, right? Should you pass away, there could be probate in Rehoboth or in Delaware, because that's not part of your main probate. So you could have probate in two states, a small probate for one property in Delaware, which requires Delaware lawyers, Delaware courts, and then your main probate here in Virginia, DC, or Maryland. All right, so probate is also a public process. Again, everybody can go to the court and see, what kind of debts you have, what kind of assets you have. So it's really not a private matter at all. And anyhow, so let's talk and hopefully clarify things for you as far as what a trust is, how does it work, what is it for. Trusts, again, the ones I'm talking about are called sometimes the living trust or living trust. Sometimes they're called revocable trust, okay, or revocable. If you want to say revocable or revocable, it's pretty much the same thing. Okay, so again, a trust is basically a document, right? Just like a will. You sign a will, you sign a trust, right? But a trust is a document where you basically create something during your lifetime. It becomes effective during your lifetime, not just upon death. And there are always three characters that need to be part of a trust. Okay, one is the person making the trust, called the grantor. Then you have the person managing trust assets, called a trustee. And then, of course, you have beneficiaries who benefit from the trust. Okay, so that's what you need to have in a trust. And now, the very important part about trusts, and that makes it different from wills, is that trusts need, to have assets. Your assets need to be connected to the trust, or your assets can be transferred to the trust during your lifetime. or some assets can actually end up in your trust after you pass away. So this whole process is called, sometimes it's called the funding of the trust. And again, it's really important if you work with another lawyer, don't skip step number 2. Okay, so don't just have an empty trust and you got a piece of paper with nothing in it, which basically it's kind of a waste of money, right? You need to make sure your assets are connected to that trust. And frankly, you could put anything in your trust, right? You could put the contents of your house. You could put, by the way, you could put your pets in your cat, your birds. They can all go into the trust. Furniture, art, all of that. The property itself can be transferred to the trust. Your bank accounts can become trust accounts. Your life insurance, well, for life insurance, obviously, you need to die first, right? Die first before the insurance company is going to give some money. So, but after death, that money can go into a trust. Okay. And then retirement assets, again, you could put, your trust as a beneficiary, upon death as well. So as you can see, funding the trust, is very important. Some of my clients kind of do a combination. They say, well, we want to have some big stuff in the trust during our lifetime, but there's a few things, that we want to keep separate or out of the trust for whatever reason, which is possible, but then the non-trust assets still have to have beneficiary designations or TODs or something like that in order, to avoid, probate. Okay, so let's continue and talk a little bit about what kind of trust would be, appropriate for a single person. So a single person, would do well with what I call an individual trust. So it's a trust for an individual. So it's just one trust where the grantor, basically transfer assets to the trust. And then you have a trustee who manages the asset, and then there is a beneficiary who benefits, from those assets. So pretty much, no-brainer for a single person. Create your trust, connect your assets to the trust, and there it is. When it comes to couples, okay, when it comes to couples, there are choices to be made. Okay. And again, those choices sometimes, do require a little bit of a discussion with a professional so that, is this the right choice for me? Is this appropriate? Is this not appropriate? There are many implications. And again, that's where we come in, where, we analyze, the couple situation. We look at your assets. We see how your assets are currently titled. Do you have a lot of joint assets? Do you have a lot of individual assets? And then we can decide, whether you should be doing a joint trust, a separate trust with individual trustees, or separate trust with joint trustees. So these are very, very important decisions for you to make. Really it's terrible if somebody just, says, okay, we're going to just do a joint trust. And then a few years later say, well, this was really not appropriate. We really needed separate trusts. And you have to start the whole process again, pay, all the fees again, so it's better to have the right choice up front. All right, let's talk about a situation where a joint trust would come into play. Joint trust for a couple, sometimes a joint trust for a couple is also called a family trust. Okay, so for a couple, then of course you have two people creating it, right? Two people create a trust, two people manage it, two people are beneficiaries. So again, this is basically one pot where you're putting in kind of joint assets. Now, what's interesting about the joint family trust scenario is that if one of the parties passes away, okay, grantor number one passes away, well, there really is no estate to be administered because the surviving grantor, the surviving spouse, still has the trust, will be managing the trust alone for their own benefit. So nothing has to be transferred out of the trust. It's almost like one person dies, but the trust continues, with just one person. And again, that's, very simple, and not much has to be done except maybe for claiming life insurance benefit and pension benefits, which is done. So that's a big advantage. At the first death, really, there's not a whole lot of administrative work to be done. So what happens at the second death? Right, when the second spouse passes away, well, that's when this trust, the trust provisions, would be implemented, and the trust typically would be liquidated, and the assets will be, distributed according to the terms, of the trust. Now, one point I will make here that is extremely important, okay, is that you have to be aware that the surviving spouse of a joint family trust has the ability to amend the trust. Okay, amending the trust. So if you have two children and you say, well, look, upon the death of both spouses, everything has to go to our two children. Well, if you die first, well, tough luck, because your surviving spouse, hopefully not too soon after you die, meets somebody else, remarries somebody that already has 3 kids, and then they amend the trust and they decide for the joint trust assets to go to the stepchildren and to your own children. And so there's really no guarantee for the first spouse that your 2 common children will get, the bulk of your assets. So there's very little control as to the ultimate distribution out of the trust. So again, some people come to me and they look at our list of packages and say, well, we want to do a joint trust, and then I analyze their situation and I see that all of their assets are separately held. Some people have a prenuptial agreement. I see that some clients are non-citizens. Some clients have children from prior marriages, and I'm like, wait a minute, a joint trust would be a complete wrong decision for you. Okay, so this is not the kind of trust that would work for you. So therefore, let's take a look at other options for couples. So a very good option for many couples, especially couples who are used to having sort of their own separate accounts. Some people say, well, this is my account, this is her account, this is, if you could kind of keep your assets somewhat separate, you could do a trust for spouse 1, trust for spouse 2, and then you allocate the assets in between, the 2 trusts. And interesting scenario under, clients who have a lot of separate assets, a lot of times they still have a joint property. So you have separate accounts, but you have a joint property. Well, that's not a problem. That's not a problem, because we quite often, for married couples, what we do is we transfer the property 50-50 to both trusts. So 50% goes in the trust of spouse 1 with the accounts of spouse 1. 50% of the property goes in trust, the trust of spouse 2. So that's not a problem at all. Okay, so this is a great solution for people. You got 2 buckets to fill. Again, for non-citizens, again, we'll talk about tax implications tomorrow. But again, this can also help with some, with estate taxes, because you have 2 tax exemptions instead of 1. And again, so there are some tax benefits for having 2 separate trusts. All right, so this is a good solutions for many couples. Some couples who are really more used to having everything joint, right? So every account is joint, the property is joint. And again, when they talk to me, and for tax reasons, for citizenship reasons, or for many reasons, I say, look, I do think you need to have separate trusts. You really would benefit from separate trusts. But then, sometimes the first reaction I get from clients is like, well, wait a minute, what are you telling me? That we're going to have to separate our assets? Some assets goes to husband, some go to wife. I mean, I'm not sure we're comfortable with that. Well, then I say, well, listen, this is the solution for you. The solution is that it doesn't matter which trust we're going to put the assets in. If we put it in wife's trust, we can have husband and wife be co-trustees of wife's trust and vice versa, meaning that during your lifetime, it really doesn't matter which trust the asset is in, because both of you have access to it, both of you can manage it. So again, this is a good solution for many people who, like to be joint on everything. Okay, so let's talk a little bit now about the 3 uses of the trust. So I do want you to understand that, the trusts have completely different roles, so to speak, in 3 scenarios, right? Again, they're living trusts after all, living trusts. So how do they work during your lifetime? And how do they work in case you become incapacitated? And how do they work when the grantor, when you pass away? And again, 3 different scenarios. So during your lifetime, let's take a scenario where our friend Florencia decided to create a trust. Well, during Florencia's life, luckily for her, she will also be the trustee, and she's also the beneficiary. So a living trust during your lifetime, you are the beneficiary, you are the trustee, you can do anything you want with your assets. Again, you don't even need a tax number for the trust. Your social security is the same, is the number that you use for the trust. Again, since it is almost tax time, um, when you file your taxes, you don't even mention your trust, because as far as the IRS is concerned, you and your trust are the same thing. So really, a trust is a mere, change of title on your assets. So for example, if your account at the IDB Global Credit Union becomes a trust account, well, on your statement, you're going to say the, Florencia revocable trust account, instead of saying, Florencia's checking. You just say, you see the name of your trust on your bank statement, but it makes no difference. Okay. All right. So that's scenario number 1. Easy, nothing to worry about. Now, let's just say, unfortunately, Florencia becomes incapacitated. Okay, so she has Alzheimer's. 2 doctors have said, look, you don't have capacity. So remember, one of the requirements for you to be a trustee of your trust is that you have to have capacity, right? If you don't have capacity, your trust will appoint a successor trustee. All right, so you're appointing somebody, obviously, that you trust. Okay, why do you call them trustees, right? So Florencia has appointed Guillermo. And of course, you have to excuse my pronunciation. My wife being from Uruguay, I don't have a choice but to pronounce things as they do in Uruguay and Argentina. So Guillermo is the boyfriend, husband, brother, it doesn't matter, somebody Florencia appointed in her trust. And in case Florencia is incapacitated, but she didn't pass away, okay, Florencia's bills still have to be paid. Florencia is alive, she has medical needs. So the trust really covers in case of incapacity, because the only obligation for Guillermo is to use Florencia's trust assets for the benefit of Florencia. Nothing goes anywhere, until Florencia passes away. Okay, so a lot of protection with the trust. Nobody has to go to court. Okay, we don't need to go to court and run for a guardianship because there's money available through the trust. All right, now let's take the 3rd scenario and explain to you. I'll explain to you how these trusts work, in case of death. And again, here you really can think of a trust as a will substitute, right? As a will substitute, because your trust can have everything in there that you wanted to say in your will. Anything, any provision that you wanted to put into your will, you can put it in your trust. Say, after death, this is what I want to happen, with my trust assets, So, all right, Florencia passed away. She has appointed Guillermo as a successor trustee. By the way, for Guillermo to have authority to act, okay, on the trust and have full control over all the assets, all he has to do, okay, is to sign one piece of paper and usually we provide that piece of paper, to our clients, which is an acceptance by the successor trustee to do the job that he's supposed to do. So it's a one page, he signs, he accepts to be trustee, has it notarized, and there it is. He has full authority. So we don't have to go to court and ask for court permission, court papers. One little piece of paper, Guillermo is in full control. All right. So now the trust, Florencia's trust upon her death. Okay, so Guillermo has a very important role now because he now has to pay all of the expenses, funeral expenses, taxes, has to, and then he has to follow the terms of the trust, right? So he has to distribute the net trust assets according to Florencia's wishes. So Guillermo cannot improvise and take everything for himself. He has to do what the trust says. Give it to charities, give it to children, do whatever. Okay, so now again, this is a will substitute with the big difference, of course, that trusts are kept private. Okay, it's a private affair. Nobody goes to court, and again, the administration, is quick, much simpler. Okay, so I think this hopefully helps you understand a little bit how these trusts work, both during your lifetime, in case of incapacity, and of course, in case of death. So hopefully you will agree with me that there are many, many benefits of having these trusts as an estate planning tool. Okay, again, you avoid probate. Now remember, you don't just avoid probate into your own state, but you avoid probate in all 50 states. So if you have a property in all 50 states and you put it all into your Virginia trust, you're not going to have probate anywhere. Okay. Again, it does protect in case of incapacity, as I mentioned before. No need to go to court for a guardianship. All right. It's totally confidential. Trusts are confidential. Nobody can, ask you about what's in the trust and, who's going to be beneficiaries. All of that is confidential. Obviously, we're not going to court, so there's no court supervision. There's no accounting needed to commissioners of accounts and so forth. Again, one point that I think I would like to stress a little bit more is how important a trust can be as an asset management tool for minors and young beneficiaries or incapacitated beneficiaries. And this is a very important point, and that is that trusts upon death don't necessarily terminate. I mean, this is a misconception that some people have. People think, okay, a person passes away, the trust is liquidated, the trust is done, and that's it. No, the trust can continue after your death for years if that's what's needed. Okay, if you have minor children, well, yes, your trust will continue until they're at least 18 years of age. Most of my clients do think that 18-year-olds are a little bit on the young side. So your trust can say, the trust assets for my children will stay in there until they have a college degree, until they're 21, until they're 25, or something like that. Again, sometimes you have an incapacitated beneficiary, or somebody with some medical or health issues, and sometimes it's better to keep the money in your trust even after your death and kind of have a cash flow. Say, we're going to have a monthly sum go to this person for the rest of their lives. So there's so many options, so many things you can do. You can put in whatever provisions you want to so that things make sense based on your family circumstance. Okay. You really do save a lot of money in terms of administration expenses. Okay, so administering a trust, you could do it without a lawyer. You could do this on your own, follow the provisions. There's not all these court fees and so forth. So you do save a lot of money when settling the estate, so to speak. And if properly drafted, your trusts can also have some special tax savings provisions, tax deferral mechanism. And again, we'll talk about that, especially for non-citizens, tomorrow. Okay, so there's all kinds of benefits by using the trust as your main document rather than having a will. Now the question I do get quite often, and so I may as well address it now, is like, if you have a trust, do you still need a will? Well, the answer is yes. Okay, any estate planning attorney will not just prepare a trust for you and say, okay, you're all settled. You have to have a will that sort of mentions the trust. Okay, so it's a will that says, hey, upon my death, go look at my trust because I have a trust. And sometimes these wills are called pour over wills. It's not a will for poor people. It is a POUR, pour over will, meaning that if for some reason upon your death we discover any assets that are not part of your trust or they're not connected to your trust, by filing the will, those assets can be added to your trust after you pass away. So the will, and of course, if you have minor children, it is only in the will that you can name a guardian. Where will those young children go live if both parents pass away? Do you want them to go back to your home country? You want them to stay in the US? Again, you have to, pick substitute parents, so to speak. So that's what I wanted to stress. Now, here's a little quiz for you. True or false? Again, does a trust require a tax number? And do annual tax returns have to be filed? Do trusts avoid all taxes? Are there annual maintenance fees? Are there fees for adding future assets into the trust? Do trusts create an administrative nightmare? Are trusts more expensive than wills? Are trusts options for non-US assets? Okay, so think about all of these questions, and if one of you said true to any of this, then you are mistaken. Okay, the answer to all of these questions is false. Okay, so let me go back from the beginning. A trust does not require a special tax number. You don't file trust returns. Why? Because again, you and your trust are the same thing, and your social security number is all that is needed. If, however, your trust continues after death for X number of years after we've discussed, then you get a tax number, but that's after the grantor has passed away. Okay. Some people think, well, I have a trust and therefore any tax problem will disappear. Well, that's not true. If you have $20 million, or I don't, there could still be estate taxes, whether your assets are in trust or not. And again, we'll talk about taxes tomorrow. Annual fees? No, there are no annual fees. You create the trust and you're good to go. You don't have annual fees. Remember, a trust is not like a corporation. It's not something like every year you have to file some fees with the state. No, it's a private arrangement. Okay. Fees for adding future assets. Well, listen, if you created your trust today, well, you can go buy a car tomorrow. You can buy a house this weekend. You can open new accounts. You just add those new assets to your trust, and there's no fees for that. You just keep adding assets to your trust on your own. Administrative nightmare? No, it facilitates things. Well, are trusts more expensive than wills? Again, I said that is false, but I can only speak for myself. I mean, I know many attorneys do charge more for trust because maybe they say that it takes more work, or we've actually made it a point, and you can look at our schedule of fees. We charge the same for will packages and trust packages. I don't want to have any difference between the two. So that's, what I can say for ourselves. And then, well, international clients with non-U.S. assets have to be very, very careful. Trusts are not for, properties abroad. Okay, so you cannot sometimes mix legal systems. So if you have a Parisian apartment or a beach house in Punta del Este, those things are not going to go into your U.S. trust. Okay. All right, so it looks like we're getting close to the end of our presentation. Let me make a couple of recommendations. and then I will see how many questions I can answer, in the time that I have remaining. Again, I think it's a no-brainer at this point, unless you really don't care, unless I don't like to use the word selfish, and but have documents in place for yourself and for your loved ones, because it does really help a great deal when they are needed. Okay. And then for international clients, again, you should talk to local lawyers in your home country. Civil law countries, sometimes, local law will automatically distribute things to a spouse and children, and maybe you don't need a will in your local, in your home country. Um, International clients from Europe, from the European Union. Okay, there's some special rules that say that if you're a habitual resident or you're a U.S. citizen, and and you live here in the States, that you could have your Maryland, D.C., or Virginia will apply to your assets in Europe. Okay, so again, you need to talk to an expert about that. It gets, some countries in Europe are part of this convention. A couple of countries are not. Okay. Again, avoiding probate, I think everybody should really make a big effort through, trusts, beneficiary designations, titling of assets, to really avoid probate, because it's a big relief for the survivors. And again, do check your beneficiary designations. I know a lot of people, starting at the bank or IDB or IMF, you fill out these papers. Sometimes you've been working for 10, 15, 20 years, and you just don't remember, who you put as a beneficiary. Maybe you were single back then and now you're married. Again, check your beneficiary designations. One little caution here, okay? Do not put minor children. Okay, do not put minor children as beneficiary designation. It's going to create a court guardianship for those children. So, put a trust. Children have to be 18 at least before you start putting them as beneficiaries. All right. On that note, let me. I think Marilyn resurfaced. I see.
I'm back. Thank you.
She's back.
I resurfaced. So thank you for everything. That was a lot. Can you hear me? Hopefully you can hear me. That was a lot of great information. So now let's take some questions, as many as we can. And then just a quick reminder before we end today, we do have 2 other webinars coming up. Part 2 of this amazing estate planning webinar is tomorrow. And then on Thursday, we're going to do how to report when a loved one passes to the IDB financial institution. So make sure you sign up for that one as well. So Mr. Forbet, I'm going to pass along the questions to you, and let's take a couple for the next 10 to 15 minutes.
All right. So I think I see them in the Q&A over here. All right. All right. Well, somebody asked to clarify what probate is. Well, we did that. We covered probate. So what happens? Okay. Someone asked about an LLC. Okay. Well, people who have LLCs, again, complicate things a little bit. A lot of people get LLCs because they're worried about liability. Of course, you can have insurance for liability as well, but an LLC is a separate entity. Okay, an LLC has its own tax number. So, a trust, you are your trust, but an LLC is a separate company. So an LLC typically would be an estate, would be an asset in your estate, and a lot of LLC actually do generate probate. Okay, I have clients with LLCs, and after a while they realized that they wanted to cancel the LLC and have a property or something put back in trusts. But again, you may want to talk to your business attorney about your LLC, whether or not that is something that you really that you need in your plan. All right, so here's a long question. Wow. Okay, so what is the importance of naming beneficiaries and establishing an estate name when it comes to estate planning for assets, bank accounts, retirement plan? Well, the importance of naming beneficiaries, of course, is to, have things go smoothly so that, there's no probate, that the asset can pass directly. Okay. Okay, so I think maybe the gist of this question might be that if you have a bunch of beneficiary designations and all of that, well, how does that impact your trust, right? So if you have an account and you have a beneficiary designation, well, then it's going to bypass your trust. So there's some things that actually do not go through the trust. Okay, so some things are direct beneficiary designations, and some things just go through the trust. Okay, so if there are no probate assets, how are debts handled, notification and settlement? Well, again, debts would be paid from trust assets, right? I mean, if you have a trust, well, then, the trust will pay all the debts. Now, if you're telling me that there's no trust and there's no probate assets, let's say everything is joint, so all of the assets go to the survivor, well, then the beneficiaries will be on the line, right? I mean, if there's taxes that are due, the beneficiary will be on the line, and they may have to pay back some of that money because, debts have to be settled. Okay. All right. So, yeah, somebody asked if a brokerage account would be considered for a TOD. Absolutely. So talk to your investment company and ask them for a TOD form. All of them allow that. Can you clarify what are the advantages of adding a POD or TOD designation in the context of estate planning? Again, having beneficiaries is a way for an asset to pass directly without freeze, without having to go through probate. So again, all of these are important. The difference between TOD and POD, by the way, it's the same thing. So investment companies prefer to use TOD, which is transfer on death. Banks typically say POD, which is a pay on death designation, but it really is the same thing. Okay, somebody asks about multi-state probate. And the question I think has to do with assets abroad, right? So again, assets abroad are not part of, are not distributed, through you will, unless of course there's a special regulation for that, and unless your will covers that, so typically you need to check with a local attorney in your country. Okay, if you have assets, bank accounts, properties, they don't go through probate here. Okay, you have to initiate some kind of proceeding in your home country so that those assets can be transferred according to local law. Okay. Can you do a living trust in one state and transfer the living trust to another state? Right. So if you created your trust in Maryland, let's say, and then you move to Florida, okay, the trusts are valid in all states. It's not because you have a Maryland trust, you go to Florida, you pass away there, your Maryland trust would still be recognized. My recommendation, of course, is that if you move to another state and if in a few years you want to review your trust, update your trust, then you talk to a local lawyer in your new state, because sometimes there's some special state provisions. I mean, why would you want, once you're in Florida, why would you want your trust to be governed, by Maryland law, even though you have nothing to do with Maryland anymore, right? All right. Well, let's see here. Are trusts filed in court? No, they are not. Again, that's the whole point. The whole point is that they're not filed anywhere. It's a private arrangement. So that is one of the main reasons for doing trusts. Okay. Okay, so some people ask somewhat private questions about working with us, our fees, and so forth. Again, you're better off emailing me directly about those things, right? So what happens to the trust and other documents if one has to relocate, as we are here with a G4 visa? Well, I guess that's a good question, right? Because a lot of G4s, I guess the question becomes upon retirement, if you are applying for the green card, you have to go back home and wait for your green card. I know this whole thing is kind of a mess, but you can go back home and keep assets in the US, and your trust is still very useful, even though you are back in Argentina or wherever you are, right? Because you still have assets, you still have a house, you still have property here. The trust will be useful, at the time of your death for distributing assets easily. So you can keep your trust even though you move back home. Okay. Okay, so somebody says that they have a trust in Virginia. Can assets in a different state go into the trust? Yes, you can have, let's say you have a brokerage account in New York, well, you can transfer that to your Virginia trust without any problem. Okay, so, all right. What happens if the attorney who drafted the trust is no longer there? Well, I guess I guess attorneys are mortals like everybody else, and some of them do retire, I suppose. Um, um, well, again, I don't know how other lawyers do, but your estate planning documents work independently. So suppose I prepared your documents. Uh, those documents could be used with any law firm. You can use them on your own. It's not because we prepared them that necessarily we need to be involved, when the trust is needed. Okay, so they're really, independent. And of course, if your attorney, retired, passed away, and you want to update with another attorney, that is possible. That is possible. So here's a good question. Does our successor trustee, and again, somebody mentioned Guillermo, right? Does Guillermo have to be a citizen or a resident? Now, this is a good point. This is a good point. Trusts don't have those kinds of rules and restrictions that you have when you're filing a will with the court. The court, requires citizens, permanent residents. A trust is such a private arrangement that your successor trustee can be a G4, can be outside of the country. They don't necessarily have to speak English for all I know. It's whatever you want. Okay, so really no restrictions as to who you are going to name. Okay. All right. All right, Marilyn, I think we're getting close. I'm sort of picking and choosing here.
Maybe take about 3 more questions.
Okay, let's do that. I know I started at all the way at the beginning, so maybe I'll start at the end here to see. All right. How complicated is it to deal with a bank if there's a mortgage and you want to transfer a property into a trust? So that is a good question. So typically, transferring a property with a mortgage to a trust, again, the mortgage doesn't change. Okay, a lot of times the mortgage company doesn't even know the property has been transferred to a trust. They don't know that as long as you keep paying the mortgage. It only becomes an issue. It becomes an issue if the property is in the trust and then you're trying to refinance, and then the bank discovers that the property is not part of your trust. Then they're going to want the new loan to be part of the trust, and that sometimes requires a mortgage opinion letter or something like that. But we transfer a lot of properties with mortgages on them to a trust, and the mortgage just remains an individual mortgage. Remember, you and your trust are the same thing. Therefore, your individual liability on the mortgage, kind of stays the same, and, just keep paying the mortgage, right? Otherwise, you'll get in trouble. All right, 2 more. Do your property taxes go up when you transfer your property into your trust? No, the property taxes are the same. Okay, because again, you and your trust are the same. Maybe the only exception to that I may have heard is if in Virginia, I think Virginia, unlike Maryland and DC, I think you guys pay some taxes on your cars, right, on your vehicles. So sometimes if you were to put your car into a trust in Virginia, they may charge you a higher rate because they consider it an entity or something like that. But again, we have a solution to that so that the trust can be listed as a beneficiary. And then, of course, the car stays in your name. You get the same result. The taxes stay the same. Okay. All right. Last question here. Let's take a look. So if you are the survivor of a joint trust, Do you have to amend that joint trust, or you have to do anything for, let's say, the children to inherit at the death of the second spouse? Well, I mean, if the trust says everything stays with the spouse at the death of both of us, it goes to the children, then there's no need to, to redo the trust or update the trust. The trust covers the first death and the second death. Okay. So I think maybe on that note, we may wrap things up, Marilyn.
We will wrap things up. So thank you everybody for attending. We know it is an amazing topic that everyone's very curious about. So we're extremely happy to be hosting this session in partnership with the Retirees Association to bring you the information that you need in order to make informed decisions. So again, you will be receiving a copy or a recording of this in your email. Look for it in about a couple of hours. Whoever registered will be receiving a recording of the webinar. Join us again tomorrow and join us again on Thursday. Thank you, everyone. We're so happy you joined us today.
And see you all at the concert on Sunday.
See you on Sunday.
Okay.
The
bye-bye.
viola.
Exactly.
Bye-bye.
Bye.